Hi guys, it's Kathy. I hope you're doing well. Day 16 p.m. That means the next video I show will be the end. I'm going to have day 17 and day 18 all together because they're just 3 short clips. I should just get them out today. That way we did it. I'm not going to make you wait. I'm just going to get them all out today. This is a long video. So, but this is the last one. And the next project that I have, the videos are not so long. Maybe there's a 2-hour video. There's 400 videos. So some of them are real short, some of them are not. So, but they're not this long. All right, let's get to it. Let's get to the last real video.
Thank you, everyone. Before we bring the jury in, we're back on the record. Has the defense had a chance to, yeah, folks, you can be seated. Thank you. I want to be ready with the verdict form. Did you get a chance to look at that? We can talk about it more formally, but
Full court.
any
I
input?
took a look at it. I didn't have any issues with it, Your Honor.
All right. Well, you can take another look at it. I just wanted to see if there were any major issues, and there are none. So
We do still need to make the record on the dangerous nature aggravator.
oh, did you folks talk about that?
And they're the ones who asked for it, Judge. I just want to make sure we have a record that they've asked to address the aggravation, the dangerous nature aggravator in the aggravation phase and not in the trial phase.
Well,
Right.
So generally, we would have an interrogatory for the dangerous nature of the offense. We don't have that interrogatory because they've requested that. Just want to make sure they waive any issues with hearing that in the aggravation phase instead of the trial phase.
if you have something, if the defense has something they want to request to be inserted into the jury verdict form, then send me something.
She's referring to the enhancement. They're alleging dangerous nature for the aggravated assault offense. And we had just requested that anything referencing any dangerous nature offense be kept out unless and until there is a conviction. And if there's a conviction, then it's appropriate for the jury to
All right,
consider.
so
That's all.
All right, so it'll be an aggravation phase thing if.
Right.
Understood.
And Judge, just to be clear, we also asked for the dangerous nature on the lesser included offenses of second-degree murder. We filed an allegation of the dangerous nature of the lesser included offenses of second-degree murder.
When was that filed?
I can give you the date. I just pulled it up a minute ago. It is filed with the court.
But that would be an aggravation phase.
Correct.
If and when. Okay.
Yes, yeah.
Okay.
So we can deal with it then if you
all right.
like.
Thanks. All right, let's bring in the jury, please.
All right, guys, this is your last chance to not annoy the jury. You got this.
Please rise. Please be seated. The record will show the presence of all jurors, counsel, and the defendant. And Ms. Larkin, you can continue with the defense closing argument.
Thank you. I just have a few more points to make before I let you go. So I'm going to try not to take up more of your time. I know you guys have been very attentive and we appreciate that. I just wanted to talk first about some of the characteristics that we observed on the victim Gabriel in this case. You saw the radio, you saw the binoculars, you saw the camouflage, you saw the photograph of Gabriel on a different occasion about 9 days prior to these events, wearing the same clothing, also carrying that radio, carrying binoculars, carrying a fanny pack. Could be the same fanny pack, could be different. But all of those things come together, and you heard testimony from Border Patrol who described what they perceive when they're observing somebody who's present in the United States illegally, carrying these sorts of accoutrements. And long story short, this is simply not somebody who's looking for the American dream. There's no evidence that this person is here for those kinds of benign purposes. All of the evidence, in fact, points in the other direction. And we bring that up not, to be judgmental about Gabriel or to not have compassion for him, but when people are involved in criminal lifestyle, it's dangerous. It's more inherently dangerous than simply being a migrant who's coming here. So it's relevant for that reason. I want to talk about what the state is actually asking you to believe, because they haven't really put everything together for you to tell you what happened in this case. And if we assume for a second that what the state is claiming here happened, then we have to try to fit that story into the known facts of this case. And that's always something we have to do. Consider the known facts of the case in next to whatever's being presented to you to see if they make sense together. According to the state, Mr. Kelly is standing in his kitchen and he sees somehow out through those windows all the way out 115 yards to where Gabriel's body is eventually located. And he can somehow see that from inside his house. You all were there. I'll let you all be the judge of whether it's even possible to see somebody from inside the house. But let's say that he does. And let's say that he sees two unarmed people who are just moving somehow out there. The state wants you to believe that he calls law enforcement and makes up a story about hearing a shot and getting shot at, and he makes up a story about seeing people with backpacks. Then the state wants you to believe that after he makes that call to law enforcement, he picks up his rifle, he goes outside, he takes aim at these people who are posing absolutely no threat to him whatsoever, and he shoots because he just wants to kill somebody on his property. That's what the state wants you to believe happened. And then after that, if the state wants you to believe what Daniel says, they want you to believe that Mr. Kelly somehow crossed over those two fence lines and stood over Gabriel's body while Daniel was running away. They want you to believe that that's what happened. Just ask yourself, does that make sense? That's just the first part of this. Does that make any sense when you put it next to the physical evidence in this case and the known facts of this case? They want you to believe that after Mr. Kelly deliberately shoots this person and sees this person on the ground, that he then somehow manages to go over to the area where his barn is after calling and speaking with law enforcement again and telling them he saw people with guns. And then they want you to believe that he brings law enforcement onto his property. Law enforcement searches his whole property. Law enforcement doesn't find the body in this case, and then law enforcement leaves. If what the state is claiming happened actually happened, that would be the end of it. But that's not the end of it. The state wants you to believe that even after Allen knew he shot this person, did so deliberately, had no threat, no justification whatsoever to do it, called the cops, they left, he calls again because he thinks, I really should just show them where this body is. They want you to believe that he decided a couple hours later to just bring law enforcement back onto his property and take them to the body. And they want you to believe that he did this without in any way trying to cover up any of his involvement in
Yo, none of that happened. No, that the state never said any of that. None of she what?
this, without picking up any shell casings, without getting rid of any weapon, and without concealing the body or doing anything like that. They want you to believe that the calm demeanor that they describe on the first call is his demeanor even after he's stood over this body and he knows he shot this person. He's calm. But somehow later when he's on the phone with dispatch, he's upset, he's distraught, he doesn't know what to do. I'm just asking you to consider whether any of that makes any sense when we look at the facts on the ground. And it does not. It makes absolutely no sense for this man, if he wanted to go out and shoot somebody, to call law enforcement right before he does it, speak to law enforcement right after he does it, right after he knows he did it, and then bring them back after he knows that they couldn't find the body because they didn't do a thorough enough search. None of that makes any sense when you look at the facts on the ground. What does make sense? Mr. Kelly sees a threat. He sees people with rifles. He calls law enforcement. He goes outside. He fires his warning shots exactly the way that he describes. He sees people moving from left to right. He turns in this direction to the right to fire over that tree that you all saw. Meanwhile, the body's discovered over there. It makes sense that Mr. Kelly did not fire any shots through that thicket in that direction. It makes sense that those shots were fired in the exact direction that he said that they were shot. And it makes sense that he continues to communicate with law enforcement. It makes sense that he's not distraught at this point. Why? Because he has no idea that there's a body there. In fact, we don't know that there is a body there when he calls law enforcement on that first call. It makes sense that he's telling law enforcement what happened and what he saw, and he's continuing to communicate. When he talks to the sheriff's department later, after he's discovered the body, it makes sense that he just discovered the body because of his demeanor in that phone call with the sheriff's department. He is upset and disturbed in a way that he was not earlier on in the day. All of the facts that we know make sense with Mr. Kelly's version of how things happened. They do not make sense with the state's version of how things happen. Nobody deliberately shoots a person right after calling law enforcement for help. And nobody, if they do that, which they don't, nobody lets law enforcement search their property, fail to discover the body, and then call them back later without taking any steps to conceal anything. Nobody does that. That makes absolutely no sense. Wanda Kelly probably picked the best word to describe that scenario, and that is crazy. Nobody does that. The standard in this case, we talked about this at the beginning, is proof beyond a reasonable doubt. This table has that burden. This table has no burden whatsoever. We do not carry any burden of proving to you that George Allen Kelly is not guilty. The state carries the entire burden of proving to you that he is guilty. And I mean proof. And in order for you to find Allen guilty of any of these offenses, whether it's second-degree murder or any of the lesser includeds, manslaughter, negligent homicide, they have to prove to you that Allen shot this person. And they have not done that. The ballistics don't prove it. The witness statements don't prove it. Allen's own statements don't prove it. The facts on the ground do not prove it.
The
They
dead
haven't
body
done it.
Doesn't prove it.
in order to prove the offense of aggravated assault against Daniel Ramirez, Daniel specifically, they have got to prove that Daniel was actually there. It's as simple as that. They cannot prove that Daniel was there. Anybody who is on Mr. Kelly's property, and you folks were all on Mr. Kelly's property, there is no chance that you could describe that property the way that Daniel described that property. This is not the house with the pine trees that is maybe west of Nogales, maybe east of Nogales, he changes. This is not the house where there's a border patrol road that goes directly to the end of the wall. This is not the house that's either 2 football fields away from the wall or 15 meters away from the wall. That is not a description that anybody could offer of this area who has been there. The only conclusion that can be reached based on Daniel's description of this property is that he wasn't there. And that's just the property. He describes other things too. He describes being 10 meters away from the house when this happens. There is no body that is 10 meters away from the house. That is not possible. He describes the house being on his left. I'm facing south. That puts him to the west. The body is located to the east. Again, not possible. Daniel describes the shots coming from away from the house, towards him and Gabriel. Not possible. You cannot find Mr. Kelly guilty of aggravated assault against Daniel because Daniel was not there. And you cannot find him guilty of any of the offenses, second-degree murder or lesser included, because they did not prove that Alan shot this person, and they have to prove it. Your jury instructions have various justifications. You're going to read about the defense of premises and what's required by law to allow somebody to defend their premises and what steps they can take to do so. You're going to read about self-defense, using physical force, using deadly physical force, and defense of third persons. All of those jury instructions describe what somebody can and what they cannot do when they're confronted with a threat. In this case, if Alan is telling the truth and his is the only version that makes sense with the physical facts that we know and that we're not guessing about, he was confronted with a threat right outside of his home. That was a threat to his life. He had a rifle pointed at him. Under any scenario, he is absolutely justified in using deadly physical force to respond to that threat. He didn't use deadly physical force. He fired shots up into the air, over the tree, over where these people were to get the threat to stop. And as soon as they turned and went the other way, he stopped firing. He didn't empty his magazine. The state's going to tell you that just firing warning shots is reckless, and just because he did that, you should find him guilty of something. That's not what the law says. The law does not say that you cannot use lesser force to defend yourself. The law does not say that when you're out in the middle of nowhere, and you folks were out there, this is not downtown Nogales, this is not a populated area, this is isolated, it is empty. He can fire warning shots to protect himself and to protect his wife. And that's exactly what he did. That's exactly what any man who cares about his wife and his home should do in this situation when faced with the threat that he was faced with. The jury instructions are going to explain to you that the state, besides having the burden of proving that Alan is guilty, they have that burden. They have the burden also of proving that Alan did not act with justification. It's up to them to prove it. It's not the defense's job to prove to you that Alan was justified in his actions. It's up to the state to prove that he was not. And we ask you to hold them to that burden. I told you at the beginning, this is a criminal case. The burden is serious. This is dead serious. And the reason that we have this serious burden of proof in a criminal case is because we really need to know before we hold somebody criminally accountable, before we go burn somebody at the stake, we have got to know that they are guilty. We can't just have suspicions. We cannot be guessing. We cannot hope that this happened because then maybe this does justice here. No, we have to absolutely know beyond a reasonable doubt that this man is guilty. That burden really requires that you folks are biased in favor of the defendant. If there are two possible interpretations of different pieces of evidence, the defendant gets the benefit of the doubt. That's how the system works. That is how we know you don't want to do something to the wrong person. Justice is not served if the wrong person is held accountable for somebody else's act. It's certainly not justice for Alan to hold the wrong person accountable, and it's not justice for Gabriel to hold the wrong person accountable for his death. Think of the burden of proof like scales. Scales balance like this. We start, the defendant is down here. He has the presumption of innocence. His scale has all of the weight. It is up to this table, it's up to the state to put weight into this other scale so that they're supposed to show you enough evidence that'll move it down, not so it's even, not so it's a little bit this way, but so their case is all the way on the floor and the defendant is now up here. That's the level of evidence that is required. And if they don't meet that, which they did not do in this case, then it's your job to find Mr. Kelly not guilty of these offenses. We want you to make this decision based on the facts, the known facts of the case, not based on subjective guesses about what somebody's words might mean, not based on, let's pick a small line in a transcript. Here, convict him based on this. No, that's not what this burden does. We are not permitted to just cherry pick somebody's words, decide what they mean subjectively, and convict a person because of that. You need facts. That's guessing, that's speculation. You can't guess or speculate. You need facts. And those facts have to be proven to you by this table. I wanted to remind you all again that we're not here to solve the mystery. If you sort through all the facts, you look at all of the evidence, you talk about it, and if you decide, I am not sure what happened here, we don't really know what happened here, that means the verdict must be not guilty. That is what that means. And the fact is, we're probably never going to know what really happened to Gabriel. And we won't know because the investigation in this case jumped to conclusions. They didn't search when they should have. They didn't preserve evidence that they should have. They didn't do tests that they should have. And now we'll never know. And when that's the case, when now we'll never know, that's a not guilty verdict. I just wanted to sort of leave you with what reasonable doubt is. It's not proof beyond any doubt whatsoever, but if you have real questions in your mind, if you're thinking, I just don't know, maybe he did, maybe he didn't, there's some evidence to suggest he did, there's some evidence to suggest maybe we're wrong about that, and then there are a lot of question marks and a lot of gaps over here that we don't know. The answer is a not guilty verdict. And if you're sitting back there in the jury room and you have those doubts, even if everybody else is all on board, if you have those doubts, then our system requires a not guilty verdict. We're asking you to have the courage to say no. It doesn't matter if there are any pitchforks or torches or anything involved. If there is doubt in your mind about whether Mr. Kelly did this, You have to have the courage to return a not guilty verdict if there's any uncertainty at all. And they have to prove it. And I'll just leave this with, we talk about reasonable doubt a lot as lawyers. If there ever was a case where reasonable doubt existed, it is this case. If you put this case into an algorithm and asked a computer, does reasonable doubt exist? The answer is yes. We all live in Santa Cruz County. I live in Santa Cruz County. You folks live in Santa Cruz County. Otherwise, we wouldn't be here today. After reviewing all the evidence in this case, if I were to imagine finding a body on my property someday, hopefully that never happens. If I ever find a body on my property someday and I don't know what happened and I don't know how it got there, I think I'd be considering my options before I called these guys. Thank you for your time.
Thank you, Counselor. Thank you, Counselor. State's rebuttal argument.
I don't believe in a lot of things that she just said. I just don't believe that he ran up to the body and stood over it while what's his name? The other person was running away. That they never said that happened. And there's a dead body on the lawn. She didn't discuss how the dead body on the lawn got there. They kept saying that this is, so far out. There's nobody around. This isn't downtown Houston. Okay? If he didn't hear anything, if he didn't hear the shot, they're 160 yards away. Do you hear people talking at that point? I don't know. I don't think so. But so there might have been a shot. If he didn't hear anything, why did he even go outside with his gun? I don't know. She said some things that just didn't happen. That's not what the state said.
You gotta plug it in. Is it on? Yeah, I do have a voice screen. There you go.
Thank you for waiting.
Thank you.
You can go ahead.
Thank you. Well, we just heard that the state has this burden. Of course we have this burden, and we would have it no other way. The defendant does get the benefit of the doubt. We would have it no other way. It's up to us to prove to you, beyond a reasonable doubt, the defendant committed second-degree murder or lesser included an aggravated assault with a deadly weapon. We welcome that burden. We welcome that responsibility. Defense just talked about looking at the facts of a case, and we encourage you to. There's the exhibits, there's the recordings, there's a defendant's interview, everything, call logs, everything. Review it, take your time, massage it, marinate over it, do whatever you need to do. We encourage that. I agree. We shouldn't guess, just the facts. You must evaluate and decide. From the stand only, no other evidence of what he's thinking. There is no evidence. There's no one had a mind reading cap of what the defendant's thinking. The only evidence you can consider is from that stand and what has been admitted as an exhibit. Attorney arguments of what the defendant is thinking or not thinking is not evidence. In shock, I'm just going to address a couple of these things. In shock, defense counsel likes to say the defendant was in shock when he found the dead body. Daniel was shot at with an AK-47 9 times, and his friend died before him. In shock. Talk about the porch door slamming. No evidence from the stand. None. The porch door slammed and made a sound. Additionally, you were out there. You walked from the living room to the outside. And did you hear a porch door slam? No, you didn't. Security sweep versus search of the property. You heard testimony from the officers. Difference between a security sweep, active shooter going out there and making sure, one, preservation of life, making sure they locate Mr. Kelly, and two, find the shooter. It's all over after that. There's no searching of the property because no one knows anyone got hit. There's no searching the property except for an active shooter or the defendant to make sure he's okay. Wanda, on the stand, said these two individuals, Gabriel and Daniel, were walking by. They were walking by. Time of death. Sergeant Rodriguez said, pronouncement of death 6:24. Death, of course, happens before that. The shooting event is at 2:30. Death happens at 2:30. The view, the shot, the direction, the injury. Look at all the evidence. You saw the view. You know he shot. You've got the direction, and we have the injury. Don't guess, just the facts. I agree. Who is Gabriel? They have a photo of him a week and a half earlier, meaning nothing. We know nothing about Gabriel. You guys can't speculate if he's a hunter. He's out there sightseeing, bird hunting. We have no idea what he's doing. And on the day of January 30th, he didn't have binoculars. There's no evidence of him having binoculars. He doesn't have a radio. That's not uncommon for migrants coming into the United States to coordinate pickups once they come into the country to communicate with a driver to get picked up. That's not uncommon. And then they said a guilty person wouldn't do X, Y, and Z. Well, the defendant lives on a property where BP couldn't tell us how many, but we do know there's a lot of cameras out there. So imagine the defendant shooting someone and proceeding to dig a grave to put a body in. He's going to be caught on film. Of course he's not going to do that. Daniel, consistent in AK-47, consistent on a red horse, consistent on the position of Gabriel when he was shot. Not possible that he was there. None of this information was known.
I really don't think he was worried about cameras finding him digging burying a body. Nope, not getting there.
Except when Daniel comes in and tells us about it. His reported false name, he owned everything. You heard on the testimony, he came in from Honduras to Mexico, and that's the name they gave him when he was a boy. And he's never hidden that fact. He took a guilty verdict, conviction in federal court with that name. He never once hid from that fact. I want to talk about this because defense counsel argued, I might have to shoot back. That's not what he says. He says, I'm being shot at, I'm shooting back. He doesn't say, I might have to shoot back. He says, I am shooting back. Some of you guys may be familiar with Occam's razor. Sometimes the easiest answer is the right answer, right? We've got two options here. This tale of 5 armed men, bandits, walking the property, shooting, not shooting, dangerous, not dangerous, backpacks, non-backpacks, or what the facts say. Defendant sees 2 guys walking his property, unarmed, goes on the patio with his AK, no warning, and shoots 9 times and hits Gabriel on the side. Sometimes the easiest answer is the right answer. We just went through this. This is the toughest job you'll ever have. It will. It is. This isn't about the character of him as a person. It's not. We're not making a judgment call about him and his life. We're not. This isn't judging his life. This is about the conduct on January 30th, 2023, and that's it. Just the conduct on January 30th, 2003. How many windmills do we chase? How many? Do we chase armed gunmen? There's no BP footage, no foot traffic, no other shell casings found on scene. No one heard the mysterious shot. No evidence of drugs, guns, backpacks, a struggle, body dragging, blood trail. No evidence of any of that. None. No evidence of a rip crew. How many windmills do we chase? When the answer is obvious. If your goal is to get trespassers off your property and they are already moving off your property, question, why shoot? If your goal here is to warn off cartel members who are already moving off your property, if this boogeyman up to 15 members with guns, the question is, why shoot at them? And finally, if your goal is to protect yourself, and if someone points a gun at you, why are you shooting in the air then? If someone points a gun at you, why are you shooting in the air? Shoot back. Leugin, BP agent Marcel. Defendant said to Marcel, who told him, I struck something. You remember the testimony on the stand when they tried to cross-examine him about something different? And Agent Leugin said, that's the first time I heard that. He testified. Defendant says he was told by Marcel, I struck something. Remember defense opening, where they claimed Detective Ainza was hostile. We heard it today, that they browbeat the defendant. No such thing happened. Professionalism. Ainza first starts out by telling me, tell me everything you know. Very open-ended question and sat quietly. You have the interview. If you don't believe me, watch it. He asks him anything you want to ask, anything that is important that's going to help out and assist me in clearing this out. Defendant responds, I don't know. I think we've been very professional, Ainza, and I thank you. I haven't been disrespectful to you. His answer is no, you haven't. There's no browbeating going on here. Ainza, I'm not here to disrespect you. I haven't been disrespectful. Question. Answer. No, you haven't. When they leave that interview, they handshake. There's no browbeating here. It's a voluntary statement by the defendant. Ainza, is there anything else you'd want to answer? Is there anything else you want to tell me before we end? I'm thinking. He's asking open-ended questions to the defendant. He wants to get to the bottom of this. Justification instructions, we saw this. There's 5 of them. Remember, it's a reasonable person standard. It's not the defendant's standard. It's a reasonable person standard. No evidence of any armed gunmen, no BP footage, No foot traffic. We talked about this. No one heard the mysterious shot. No evidence of a robbery, dragging, anything of the sort. None. There's no justification seeing two armed men walking 2 fences away, 115 yards, pulling out your AK-47, stepping on the patio, no verbal warning, and shooting 9 times. No justification for that whatsoever. Important 2 concepts. We just talked about reasonable person standard. He escalates the situation. His wife is fine. She testified. She didn't grab her gun. She didn't lock windows. She didn't lock doors. There's no danger here. Justification. You do have the right not to retreat. You do. We don't argue that. However, you do not have the right to use deadly physical force to protect a person who didn't need protecting. And you don't have the right to use deadly force when there is no threat to home or yard. And you don't have the right to initiate, instigate, or escalate with deadly force. No right whatsoever. Reasonable doubt, we just talked about that. Leaves you firmly convinced. We don't know everything with absolute certainty, but it leaves you firmly convinced. Use your common sense and everyday judgment. It's not a mystical thing here. Firmly convinced, and nothing is known with absolute certainty. Use your best judgment. No guessing, just the facts, and we'll end with this. Gabriel and Daniel were shot at. Gabriel is dead, killed by a high-powered weapon, an AK-47. Entry wound, exit wound, lined up with the defendant's property. Defendant's words, and it's a typo, inconsistent with the physical evidence. Inconsistent. The victim's statements, consistent. Steps out, no verbal warning. Defendant shot his AK 9 times. Shell casings prove it. Ejection pattern proves where he was standing. Position and orientation of Gabriel's body proves where the shot comes from. Find him, the state's going to ask you to find him guilty of second-degree murder. We also have, if you don't agree, manslaughter. If you don't agree with second degree or manslaughter, you can find him negligent homicide. And also find him guilty of aggravated assault with a deadly weapon. He manifested everything in this situation. He escalated it. And I'm going to leave with this. The moral of the story, again, is you shot and someone's dead. The answer is yes.
All right, thank you. That concludes the closing arguments. Ladies and gentlemen of the jury, I need about 5 or 10 minutes just to finish a verdict form. This is the form that I'll give to you when you go back to deliberate. They'll have to complete when you complete your deliberation. So I'm going to stay here. I'm going to excuse you. It should just take 5 or 10 minutes. I'll stay here with the lawyers. We'll excuse the jury, and we'll have you back shortly.
Please rise, the paper forward. Please rise.
Oh, I hope this is not painful. Don't end painfully,
Let Louis
please.
do that. You go do that.
Maybe they'll fight a little bit now that it's over. The lawyers?
Thank you, everyone. You can have a seat. Jurors are absent. All right. We're just going to finalize the verdict form. Should just take a couple minutes, and we'll be right back.
Please rise.
Oh, they're not going to do it with us. Okay. Okay. Let's see how many pauses we. Oh, look at that, guys. This is not going to be a long video. Oh my gosh, I could finish today. I could do them all today. Who would have thought when you woke up this morning that you were going to get to the end?
All right, thank you. We're ready with the jury verdict form. We can bring in the jury.
This is going to be a tad boring, guys.
Ready to swear the bailiff?
Please rise.
Please be seated. The record will show the presence of all jurors, counsel, and the defendant. Ladies and gentlemen of the jury, this concludes the closing arguments. I now have two brief closing instructions to give to you. I'll explain the verdict form, then we're going to pick the alternates, and then you'll be discharged to go and begin your deliberations. Final jury instructions, two final jury instructions are as follows. The jury foreperson. When you go to the jury room, you will choose a foreperson. The role of a jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. So in other words, there's no discussions, no deliberations unless you're all present, even if someone just steps out to use the restroom. You all have to be present. The jury person is to preside over deliberations and make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. All jurors should be allowed to state their views about the case and what they think the verdict should be and why. All members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. If you reach a verdict or verdicts, fill out the verdict forms and then sign the form on behalf of the jury. That's what the foreperson does. If the jury reaches a verdict, the foreperson will inform the bailiff. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict forms as well as any question forms that have been used. When you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. The case is now submitted to you for decision. When you go to the jury room, you will choose the foreperson. He or she will preside over your deliberations. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and with the approval of the court. After you have decided on a schedule, please advise the bailiff. You are to discuss the case and deliberate only when all the jurors are together in the jury room. Do not discuss the case with each other or anyone else during breaks or recesses. The admonition that I've given you before and during the trial remains in effect when all of you are not in the jury room deliberating. After you're setting your schedule, I suggest that you next review the written jury instructions and the jury verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations, or should you wish to communicate with me on any other matter, please use the jury question form that we have provided to you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note, and I will consult with counsel before answering it in writing, and I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or after you have been discharged. All 8 of you must agree on each verdict. You must be unanimous. Once all 8 agree on a verdict, only the foreperson needs sign the verdict form on the line marked foreperson. You will be given verdict forms, and I'm going to review those with you now. So, what happened to the overhead projector?
Judge,
Can I use
no,
it? Oh,
we're so
what happened to the
close.
projector? Did we take it out?
No.
Yes. All right, let me have the break. Well, I was hoping to put it up here while I discuss it with the jurors. I didn't realize that, well, you don't have the one that I did, though.
I can email this to her. She can pop it up there.
All right, email it right now. I do want to discuss this. I want you to see it as I'm going through it. I'm sorry, I thought I had that projector's been up the whole trial. I just assumed it was still up there. All right. So he can email it to, all right, appreciate that, thanks. So while they're doing that, let's discuss something I was going to discuss with you after I went over the verdict form. Anyway, scheduling. As I said, we're going to pick the alternates. You're going to start to deliberate. We shut down the courthouse at 5 o'clock. So when you're still deliberating at 5 o'clock today, we're just going to excuse you for the day. You're not going to have to come back into court. I'll send the bailiff in, and he'll tell you you're excused for the day. Then you can set your schedule. We expect you to come back tomorrow and keep deliberating. You can decide what time to start. Court's open. The courthouse opens at 8 o'clock. If you want to start at 8:30 or 9, it's up to you. Okay? So you'll be discharged for the evening tonight at 5 o'clock or before if you want to go home earlier. Set your schedule. Let the bailiff know what time you want to start tomorrow so we can have security there to let you in and so forth. Then tomorrow, as you're deliberating, again, you can take lunch, go out for lunch from 12 to 1:30 if you want a break. If you want to eat lunch in, the clerk and the jury commissioner, he'll bring lunch in. Let us know, but you kind of got to let us know by like 10 or 10:30 because, ordering and getting everything prepared, we got to start that process ahead of time. If you tell us at 11:30 or 12, you won't get fed until 2 or 2:30, the way things work. So let us know if you want to eat in and keep deliberating, or you can take a break from 12 to 1:30, whatever you want to do. Just let the bailiff know. As this instruction said, any questions or any comments, any communication between the jury and the court has got to be through the bailiff and has to be done in writing. Everything has to be done in writing. It should be a note either signed by the foreperson, or if any of you individually want to send a note through the bailiff. And as I said, I'll get it. I'll confer with the lawyers and we'll come up with a written response. Exhibits. When you go back to deliberate, the lawyers and the clerk will be working here with the bailiff to put together all the exhibits that we'll bring back into the jury room. You'll have access to everything that was admitted as an exhibit at trial. Now, there's some things, obviously, we're not going to bring back there so anyway, we're going to bring everything back there that I approve of for right now, but there are going to be some things we're not going to bring back there, but you can still have them. For example, the clothing, bloody clothing, coats,
Live ammunition.
firearm, shell casings, those physical exhibits will remain here, but they are accessible, all right? All you have to do is write a note saying, we want to see the clothing, and someone will bring it in and you'll be able to look at it, for example. Now, some things were admitted and electronically. There's some recorded statements, some videos, some 911 calls, and those are all electronic. Those are accessible to you as well. just let us know what you want to see. And if you want to see them, then we'll have one of our tech people bring in a laptop computer. I think there's a television monitor on there, and they will play for you whatever you want to see. And then they'll remove themselves so you can talk and deliberate about it. So if you don't see something in the jury room, it's because it's just not appropriate to bring it in there at the present time. But if you want to see it, tell us, ask for it, and then we'll have it brought to you. All right? That's going to take a little while to get together because with a lot of exhibits in this case, so it may take a half hour, an hour or so to get what we can bring back there to you. All right, how are we doing? Oh, there it is. Okay, great. All right, do you have that on your screens? All right, thank you very much, counsel, for helping out. All right, so this is the form of the verdict. We, the jury, duly sworn and impaneled and sworn in the above title action upon our oaths, do find the defendant, George Allen Kelly, on the charge of second-degree murder on January 30, 2023, as the result of the death of GCB as follows. All right, thank you. Check only one. All right, so this is the charge, and count one of the charge against the defendant, second-degree murder. Check only one. Guilty, not guilty, unable to agree, or guilty. All right, now, we have these lesser included offense instructions, lesser included offense charges that the lawyers have argued to you. The verdict form explains to you when you go to those and what you do with respect to them. Lesser included offense verdict on manslaughter. Manslaughter is one of the alleged lesser included offense instructions. It's a lesser included offense of second degree murder. If you find the defendant guilty of second degree murder, do not complete this portion of the verdict form. In other words, complete this portion only if you find the defendant either not guilty of second degree murder or you are not able to decide. All right? Real simply, if you find the defendant guilty of second degree murder, you don't go to the lesser included offense instructions. If you find the defendant not guilty of second degree murder, or you're not able to agree, then you check not guilty or unable to agree, and then you go to manslaughter. All right? Are you with me so far? All right, it's a little confusing. All right. So if you get to manslaughter because you found not guilty or unable to agree on second degree murder, then we, the jury, impaneled and sworn the above title action and upon our oaths to find the defendant, George Allen Kelly, on the charge of manslaughter on January 30th, 2023, as the result of the death of GCB as follows. Check only one. Not guilty, unable to agree, or guilty. All right? Now, there's another lesser included offense instruction, and the second lesser included offense charge is negligent homicide. The jury verdict form explains to you how to deal with that. Lesser included offense verdict on negligent homicide. If you find the defendant guilty of second degree murder or manslaughter, do not complete this portion of the verdict form. In other words, complete this portion only if you find the defendant either not guilty of second degree murder and not guilty of manslaughter, or you are unable to decide on either of those other charges. Then you render a verdict on negligent homicide, the second lesser included offense instruction. We, the jury, duly impaneled and sworn in the above title action and upon our oaths to find the defendant, George Allen Kelly, on the lesser included offense of negligent homicide on January 30th, 2023, as follows. Check only one. Guilty or not guilty. All right? All right. You may not have any questions about that now, but if you go back to the jury room and at some point, if you're not sure about what you're supposed to do with respect to these lesser included offense instructions, send out a note and we'll come back in and I'll.
You know, I feel like I'm a juror and he's talking to me right now. So it's really not as boring as I thought it would be. Like I can literally put myself in their shoes. I'm already thinking about evidence that they might ask for and questions that they might have and what they're going to eat for lunch and everything. It was not really that boring today.
Try to explain it in a better way or differently. Right? There's only one form of the verdict. That'll be sent back into the deliberation with you. Leave those copies of the final jury instructions on your seat. You're going to get a one final copy for use of all the jurors. Any questions about setting your schedule?
Judge, did you want to go over count 2?
Oh, yeah, I'm sorry, count 2, thank you. Sorry about that. Count 2 is straightforward. There's no lesser included offense instructions on count 2. Count 2 deals with the separate victim, who is Daniel Ramirez. That's count 2 is aggravated assault with a deadly weapon. We, the jury, duly impaneled and sworn in the above title action and upon our oaths to find the defendant, George Allen Kelly, on the charge of aggravated assault, deadly weapon, January 30th, 2023, as a result of his conduct against Daniel Ramirez, guilty or not guilty. No lesser included offense instructions concerning that particular charge. Sign the foreperson with your name and your juror number and whoever the foreperson is, because we've protected the identities of all jurors, and that will be ultimately redacted from the final verdict form. So don't worry about that. All right. Now we're going to pick the alternates. As I told you, the way we do things in state court, we never know who the alternates are. There will be 8 jurors who will deliberate. We're going to pick 4 alternates. We have a very
Don't pick me.
high-tech method of doing this, okay?
Don't pick me.
And just to show you, so I believe in transparency, here's how we do it. All right, you ready? This is our high-tech method of doing it. Well, there's always controversies about ballots and ballot, counting and stuff like. So let's just keep it low-tech, okay? So each of your numbers has been put on a piece of paper by the clerk. She's folded them up, and there's 12 little pieces of paper in here. I'm going to blindly pick them out, then I'll give it to the clerk, and she'll read the name of the first alternate. We'll pick all 4 alternates right now. If your number is called, just please remain in place because I have some final words and instructions for the people who will be alternates. All right? Very dramatic here. Okay. I get one. All right.
Juror 10. Juror 4.
Is that just one?
Yes. Juror 8. Juror 3.
All right. Jurors 3, 4, 8, and 10. Talked about this once before, but let me remind you. I'm going to excuse you in a moment, and if you have things in the jury room, you can go get them. And if you want to say goodbye to your fellow jurors, you can do that as well. The admonition that I've given you about not talking about the case with anybody, not doing any research, not doing any investigation, staying off the internet, staying away from all exposure to anything having to do with this case is still in effect. It's in effect until we call you and tell you that you are released from the admonition. Remember what I said yesterday in response to the questions from one of the jurors. The reason that we do that is these 8 persons who remain are going to go and start deliberating. If one of them has some kind of personal issue, a health issue, a family issue, some kind of emergency, and we need to excuse the juror who's deliberating, then we're going to pick one of you from those, one of the 4 of you, just the way we did. We'll call you and you'll have to come back and join the deliberations. And then we'll have to start all over, but that's okay. And this does happen. You can't predict emergencies or things like that. So it does happen that we have to call alternates and say, come back in, we're going to need you to deliberate. Once the jury has reached a verdict, you will be immediately notified. You'll be told that you're released from the admonition, and you'll be told what the verdict is. Any questions about that from the alternates? All right. Before you go, I probably won't see you again, and neither will the parties. I just want to, on behalf of everyone here in the court, and I want to thank the 4 of you who served as alternates. On this, we have all talked about, you know, informally among us, what a terrific jury this was, how much attention you paid, how engaged you were, and the great questions that you wrote. I just want to, it's been a tremendous commitment. I'm sure it's been a kind of an emotional experience for you. I hope you found it valuable and rewarding. I'm sure it's been stressful, with, especially with the admonitions and the controls that we put on you. I just want to thank you from the bottom of my heart for what you did. And I hope you learned something, and I hope you found it was a valuable experience. And if I don't see you again, my sincerest thanks for your service in this case. All right, I will say goodbye to your fellow jurors. And then I'm going to excuse the FAR alternates, and if the remaining 8 jurors will remain in the courtroom. So jurors number 3, 4, 8, and 10, you're excused.
Please rise if you have a floor.
The remaining jurors, please remain in the courtroom. And then you stay here. And you can leave your notebooks in the jury room. Thank you. All right, please have a seat. And now I'm going to ask the clerk, Jose, come on over here. Clerk's going to swear you in. I'm going to ask the clerk to swear in the bailiff.
Do you solemnly swear that you will take charge of this jury, that you will conduct them to a private and convenient place to inquire into the offense submitted to them, that you will not suffer any communication to be made to them and keep them until discharged, so help you God?
I do.
All right, thank you very much. All right, and we give the verdict forms to the clerk to be delivered to the jury. Anything else from counsel before I excuse the jurors to begin deliberations?
No, Your Honor.
No, Judge.
Ladies and gentlemen of the jury, you're excused to begin your deliberations. As I said, we'll excuse you right before. Yes, leave those there. Please leave those copies of the jury instructions there on your seats. As I said, you'll get a court final copy for your use among yourselves in the jury room. We're going to excuse you a little bit before 5 o'clock. Let the bailiff know what time you're going to come back tomorrow and what you want to do for lunch and all that. Any questions from the remaining jurors? Very well. Thank you very much, ladies and gentlemen. The bailiff can take you out. You're excused to begin your deliberations.
Please rise if you have a floor.
I bet we still have some stuff with the lawyers to go through.
And the
No.
record will reflect that the jurors are beginning deliberations at 2:40 p.m.
I'm going to say she's the first one to talk, but it might be the oh, she's the first one to talk, but it might be the judge. Let's see.
We'll deal with that now. Okay. All right. All the jurors are absent. You can be seated.
I would-
Counsel, if you would work with the clerk of the court and the bailiff to identify make sure that the exhibits that are admitted that are going to the jury room are consistent with your records of what's been admitted. And I think we pretty well know what's going to go back there and what's not going to go back there. If they, as I told them, if they want to see something that's in some electronic format, we'll let you know, but basically they'll tell the bailiff and we'll send somebody in there from either from security or the bailiff or a technical person to let.
They have a laptop prepared already in case they want.
I have a laptop. Okay. If there's questions and how else do you want us to contact you? I really like to deal with the questions as quickly as possible. I know your office is a little ways away. Do you want to do it remotely? I really, go ahead.
We were probably just going to hang out.
Oh, that's fine. All right, that's fine. If you don't, that's fine. If you decide to go back to your office, let us know so we can make
Will do.
arrangements. All right, anything else? All right, we'll be in recess pending jury deliberations.
Whoa,
We
she
rise
didn't say
before-
anything. Rhonda, we still have to go over a motion for blah, 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 blah. The non-aggravated, aggravated of charge 3 of the lesser included. All right, this is probably just jury questions, I'm guessing.
We received an
I'm gonna leave it there. We received, yep, jury questions. Come on, jury, get it together. We're on the edge of our seats here.
All right, well, are you ready? All right, very well. We're back on the record in State versus Kelly. We received a note from the jurors at 4 p.m. The county attorney's on the line. Defense counsel and the defendant are here in the courtroom. The jury's obviously not present. The note that I have is from juror number 1, and is there an exhibit index for both the prosecution and the defense? So I'll hear what the parties have to say. My inclination is to give them an exhibit list and have the clerk prepare a redacted exhibit list just to show what's been admitted instead of showing everything that was marked and not admitted. And now Jose
I think
said,
that's perfect.
all right, now there's another note. They just told Jose they have another note. All right, well, let's deal with the first one. Do you have any issue with that, defense counsel? We'll show you the redacted list if you want to see it.
Yeah, my only question was, some of them were multiple photos. Were they just going to say photos, or how were they going to label?
Why don't we, and if Ms. Hunley or Mr. Jetty, if you want to come over, she's preparing a list that just shows what's been admitted. So we don't send the exhibit list back there with,
Sure.
So, all right, why don't you, all right, so can we get a transcript? Here's the other note, which just came in. I'm marking these for 1824 at 4:07 p.m. Can we get the transcript of Dr. Tim's testimony? And that's from juror number 1 also.
No, there's no transcript. They need to ask a question, and you can't, the poor court reporter.
All right, let's see. Now there's a.
Go to work right now. They gotta recall the testimony.
That was long testimony.
Yeah, but they just need to be told to recall the testimony, and there's no dispute, so.
Well, I know the court, I'm just looking for the rule. There's no transcript, but the court can have certain testimony read back to them if they can be more specific about it.
Yeah, if they have a specific question, I think the court can read back specific testimony.
Let me see if I can find the rule.
I'll look through here.
All right, so why don't we answer the first question first? Why don't I, this is about the exhibit index. Why don't I just say, yes, one is being prepared for you and will be given to you as soon as it's available. Fair enough?
Yes.
That works.
Yes.
Yes, one will be prepared for your use and will be provided to you as soon as it is ready. Good. All right, I'll just write Judge Fink. 4:10 p.m. All right, so take this to them and then bring it back when they're done with it so we can make it part of the record. All right, now. What's that? Okay.
Oh my gosh, this is taking the longest. Come on, guys. Don't just sit there.
And then did you want to
I mean, yeah, let me see that first. Thank you. All right, the clerk has prepared a redacted exhibit list that just show the exhibits that were admitted. Ms. Hunley, do you want her to, defense counsel are here in the courtroom.
We're on the way over right now, Judge. We're walking as
Okay,
we speak.
all right, why don't you run, thanks. All right, and then we'll wait for you to come over here. Why don't you run another copy? And then you can give this to defense counsel, and then the other copy we'll give to the state when they get here. And here's, let me give this first question. Mark that number 1, okay? And I'll mark this number 2. Okay. Here's the rule I was looking for. 22.3, repeating testimony and additional instructions. Repeating testimony. Ms. Hunley, are you still on the line?
Yes, Judge, we are. We're listening. We just have you on mute.
Okay, no, I just
You
want to
don't
be,
hear
I just
us.
want to be sure you were still on the line. All right, repeating testimony, 22.3. If after the jury retires, jury requests that any testimony be repeated, the court may recall the jury to the courtroom and order the testimony read or replayed. The court may order other testimony repeated so as not to give undue emphasis to particular testimony. Well, let me tell you my preliminary thoughts, and then I'll hear from the parties as well. Dr. Kim's testimony was lengthy. I think my proposal would be to respond to them would be, there is no transcript, but if you're able to identify specific parts of that testimony that are of particular interest, the court would consider having that read back to you. But I'm not inclined to just bring them in and have them read 2 hours or whatever it was at time. I don't know how long it was, but 2 hours more of testimony.
No.
The state agrees to that, Your Honor. I think the court could, if the jury can identify what specific topics they need, that seems appropriate.
What are your thoughts, defense counsel? You can take a look at the rule. It's 23.3. Subsection A.
Yeah, I think if we get something narrowed down by topic, then we could consider whether that would be feasible.
All right, let me see if I can come up with some language here.
Is this just states?
No, there aren't any defense exhibits on that.
Oh, you don't have it? Give me a second.
There's no defense exhibits on
That's
It's all state.
all numbers.
It's not, maybe I.
No letters. Thought you were being biased. We just kidding. Thank you. Ours is shorter than theirs.
there you are. Okay. I'm just trying to craft a response with that. Hold on one second, okay?
Oh,
Let me
sure.
just finish this.
We're holding, Judge. We're holding on. We're about done, though. We want to know. Somebody go up there and write that for him.
All right, here's what I drafted in response to note number 2 about the transcript of Dr. Tim's testimony. I wrote as follows: Dr. Tim's testimony has not been reduced to a transcript, so no transcript is available. The court, however, may authorize the testimony read to you in open court. Dr. Tim's testimony, however, was lengthy. If there is a specific part of that testimony that the jury considers to be particularly important, the court would consider a rereading of that portion of the testimony if that is important to your deliberations.
No objection, Judge.
Any objection?
No.
All right, then I'll put Judge Fink. And that's at 4:18 p.m. Okay, Jose, so then take this into them again, let them read it. Hopefully I try to print as clearly as possible and then bring it back for filing.
States reviewed the exhibit list you provided for the state and the defense, and we don't have any objection to those going to the jury.
Does that have the defense exhibits on it?
Two
Yes, it
lists.
does.
There's 2 separate lists.
Okay, let me, can you grab that? Let me see what you have there, just so I can look at it too, those 2 lists. That's all right. All right, thank you. Okay, so these are good. Counsel, that looks, are you good with that? All right. I'll print out another set, okay? they're probably writing their response, so. All right, so we've had, just to recap, we've had two notes from the jurors, one about 4 o'clock, one about 20 minutes later. The first note was requesting an exhibit list of exhibits that had been elicited, had been admitted in evidence, one both for the defense and for the state. The clerk of the court has prepared such exhibit lists. The exhibit list that the clerk keeps includes all of the exhibits that are marked and whether they've been identified or admitted or not. So the clerk's prepared a list of redacted list, which just includes all of the exhibits by number, date identified, date admitted, and a description for both the defense and the state. And the parties have reviewed those. So when the bailiff comes back, I'm going to have him take these lists and give them to the jurors. I have a duplicate copy, and I want to make this part of the record so we have a record of what we gave to the jurors. How should we mark this?
You can just file it. That's
All right.
admitted exhibits, Your Honor.
All right, so these are, I'm going to write something on top of these. I'm going to write response to jury note number 1. All right, so I marked both of these response to jury note number 1. I'll give these to clerk so that I'll be filing in for a record. All right, now you can take. Oh, okay. So they didn't write anything? No. Okay. All right, so there's no response on that, so I'll give that note to the clerk. You can take these into the jury. This is the response to the request for the exhibit list. Yeah. Okay, so the jury has asked them to be excused for the day. So we'll do that. The second note from the jurors had to do with their request for the rereading of Dr. Tim's testimony. I wrote a response that says, basically, after having consulted with counsel, that there is no transcript of Dr. Tim's testimony. There's no transcript of any of the witnesses' testimony as far as I know, certainly not a final transcript. So I responded that there is no transcript of Dr. Tim's testimony. One has not been prepared, so one cannot be provided. However, if there's a particular part of Dr. Tim's testimony that is of particular interest and importance to the jury, the court would consider having them come back into court and have a rereading of that portion of Dr. Tim's testimony. Dr. Tim's testimony was very lengthy. I don't know, it was probably like 2 hours or so. So it's not feasible to read back the whole thing. But if there's some particular part of her testimony that they think is important, and they can identify that, then we'll consider having them come in tomorrow and read that. I suppose it would have been helpful to know that now. So
That's what I was going to say. If I could make a suggestion, I would ask that we give them that response before they go home tonight.
I did.
That way
I
maybe
did,
they
and they
can-
just sent it back.
Oh,
So
Oh.
they're on their way out. But yeah, so anyway, we'll find out tomorrow. We'll see what they say tomorrow. But
just thinking about Denise. So she could put it together.
she'll start working on it. I knew she would. All right. So we've excused the jury for the evening. I think Jose said they're going to come back at 8:30 tomorrow morning. All right. So I think you're all excused for the evening.
Your Honor, can you order the exhibits now?
Oh, I'm sorry. I'm also ordering, as is usual, that any exhibits not admitted by either party, you're. All right, any exhibits not admitted are to be retrieved by the respective parties and kept for in a secure place and with security for any future need. But the clerk doesn't keep any exhibits that were not admitted.
And just logistically, Judge, once we have the portion of the transcript or however it is that the jury has identified it, how do we read that to the jury? Do
The court reporter reads it,
court reporter just read
Right,
it? Okay.
yeah. but
Just wondered if you needed us to bring people, or I just want to make sure we were prepared, whatever you wanted us to do.
I think
Okay. I'm going to keep going. I'm going to go get the rest of it. So I'm going to pause for a second, but you won't notice, so I get the other video queued up. Okay, guys, this is day 17 a.m.,
Back,
bright and early in the morning.
geez, good. Back on the record in State versus George Allen Kelly, CR 2023-026. The jury, for the record, the jury began deliberations this morning at 8:30. At 8:30, the court received the following note from the jurors. Two questions, or two things. One, we need clarification of site visit. Was it demonstrative or an exhibit entered? Second thing is not a question, it's a request. Can we get multiple copies of the jury instructions, one for each juror? All right, let's deal with that one first. What's the state's position
I don't have any objection to that, Judge.
to the instructions?
We don't have an objection.
All right, good. So let's make sure, we'll copy off, 7 or 8 others. Just make sure they're all working off the same final instruction. All right, what about the site visit?
It's substantive, Your Honor.
Substantive?
Yeah, I mean, they're allowed to consider what they viewed out there as substantive evidence.
What was their question?
The question was, we need clarification of the site visit. Was it demonstrative or an exhibit entered? Admitted.
I don't know what.
I don't know why it makes a difference.
I think they're
Yeah.
trying to determine if what they saw out there was substantive evidence or if it's just a demonstrative, and I think it was substantive.
I know what do you have a position? It's the equivalent, well, the parties stipulated that locations 1 through 15, was it, were the locations that were specified, on the map, on the key to the map, or the key to the list that they got, right? I mean, so that was, I think an answer would be to that effect. The locations that were marked 1 through 15 were agreed to by the parties as being the locations identified in the key to the map, and you can consider that as substantive evidence of those locations.
Well, don't forget, Judge, don't forget that they added another point, and that was that tree. So I
Oh,
don't
the
know
tree
if you
as
want to
well.
be that specific and just call it, the whole thing is whatever you want to call it. But I think they can consider that location, in our opinion. I don't know.
Yeah, I forgot about the tree. But at 15 was the last thing that was the other pump house that
Yeah.
we drove them out to.
Yeah.
And then, 16 was not
Designated.
marked, but it was the end of the border
Yeah.
wall. And the
Oh,
tree, the parties went out there and agreed on the tree, so, right?
Yeah, I think anything they saw there was substantive evidence. That was the purpose of the
Yeah.
visit, was for them to judge distances and what they could see, all that
I
stuff.
mean, I agree. I just wanted to hear what your position.
Yeah, I don't think we need to, personally, I don't think we need to say 1 through 16, whatever, just the site. I mean, it's just, they may consider that.
Okay.
Just leave it vague.
That does raise an issue, though. We had asked that the photos that were taken by court administration be made a part of the record, just for the appellate record, in case anyone ever raises an issue about what happened.
All right, well, that's a separate issue. Let me deal with this.
Sure.
All right. All right. Well, you already have all those copies, right? So okay. We don't have to copy them off. We still have them, I think. All right, so answer 1, you may treat / consider the site visit as an exhibit. It is not demonstrative evidence. Number two, yes, extra copies of the jury instructions will be provided. Any objection?
No objection.
You can give this to them, and when you bring it back after they've seen it, give it to the clerk, and it'll be made for filing, and it's 8:45.
And then can we talk about that issue with respect to putting the photographs in for the appellate record?
Yeah, we will. Not right now. I got something else I have to do.
Okay.
All right. We're in recess.
Please rise.
Okay. Well, that was really quick.
You, please have a seat. All right, we're back on the record. Record show the presence of defense counsel and the defendant. The jury is not present. We have another request from the jurors. Who do we have on the line from the state?
Your Honor, Kim Hunley and Mike Jetty from the state.
All right, good morning. So I marked this question came in at 10:05 a.m. Actually, it's not a question. It's a request. We need clarification on evidence admitted for a limited purpose and other acts, parentheses, pages 19 to 20, of final instructions. We are missing context.
Your Honor, I would suggest that what the state offered in terms of the limited evidence be read to the jury or be provided to them on the limited evidence issue. And we can talk about, and I wouldn't have an objection to sending them a message with respect to the text messages on the other act evidence.
Judge, I think that unduly overemphasizes that kind of evidence. We would suggest instead maybe something where you just told them at various points during the trial, I provided certain limiting instructions regarding certain pieces of evidence, and your notes and recollections can refresh that. But for example, I talked a lot about hearsay and things were offered for limited purposes. So what you recall about the trial is what that is about.
Right. I mean, but the problem with that is that's what I actually did in the closing instructions, and obviously it's not enough. What I would, and the reason I did that, and the reason it continues to be a difficult challenge to comply with this is that, there were a number of different things that were admitted for limited purposes, for different reasons, different types of evidence for different reasons. But I think we should try to respond to the request for information. So what I would suggest is that I write them back a note saying we intend to respond. The information is somewhat detailed and involved. We're working on a response. It'll take some time because it needs some work. And we'll get it to you as soon as we can complete it. Now, I would have the parties see what you can agree to as far as what the evidence was that was subject to the limiting instructions and what the limiting instruction was at the time.
May I get clarity? Is the note asking for which ones, or can we ask which ones are there in question about whether it has a limiting instruction?
I thought, it does not. It's just as read. Okay, we need clarification on evidence for a limited purpose and other acts. See pages 19, 20 of final instructions. We are missing context. That's all it's saying.
Can we ask if there's a specific question or evidence or a statement made that they're in question on whether it is or not, versus giving them the whole trial of it?
I'd object to that, Your Honor. They've asked generally, and I think we should answer their question.
Well, I think we can do both. I think we can do both. So what I intend to write is just what I said. We intend to respond to your request. We are working on it. It will take some time because of the number of different things that were admitted in trial or for which a limiting instruction was given. However, if you have some specific evidence and you're concerned about what the limiting instruction was or whether it applies to that evidence, please let us know and we will address that specifically. So let's try and do both, and we can get a response back. If they say it was concerning this particular item of XXX or whatever, then that helps us. But in the meantime, I'd like the parties to work on this, and that would expedite the process and expedite any decisions that the court has to make about how to respond.
Well, Judge, I've already emailed to the parties and to the court what my proposal was with respect to the limiting instructions on Detectives Barba and Detective Rodriguez with respect to Miguel, Ramon, and Daniel. And so I've already sent that language. If council wants to take a look at it and see if they want to make some edits to it, we'd certainly be happy to talk to them about that and see if we can come to a stipulation to come back to the court.
That's what I'm asking everybody
Well,
to do.
My concern is if we're going to give them some, it has to be all. And I'm not sure that's what they're asking for again. But, you know, I think that's a lot of work because the court reporter, I guess, would be the only source of every single instruction. And so I'm just saying is I don't want to do just what the state wants that on. I want all of it because we don't know what they're asking.
All right. Let me craft an answer here. Thanks.
Come on, Judge. Well, actually, this isn't that much longer. Just a few more minutes of fighting. Judge. It looks like his head is still down. It looks like he's still writing. I'm bumping it forward. Still writing. There we go. His head pops up right about here.
All right, here's what I wrote. The court understands your request and is preparing a response. Two different forms of response, however, are available. First, we can prepare a response that tries to list all individual items of evidence admitted for a limited purpose. We can do this. It will, however, take some time. Second, if there is a particular item or items of evidence that was admitted for a limited purpose and the jury has a question about those particular items, the court will prepare a response as to why that item or items were admitted for a limited purpose. Either response is acceptable and doable. Please let us know how you would like us to proceed. How's that? Ms. Hunley?
Your Honor,
In the meantime, I still want the parties to start working on the more comprehensive response and let me know what you come up with. So if they decide they want the comprehensive response, then we can try to make that happen.
And Your Honor, we're going to head over as soon as we get off the phone and start working on that with counsel. But I would still like to provide a comprehensive response to the jury as to those two issues, one way or the other. We requested it before. I don't want to waive any objections that or any issues with respect to that. And so I think they're entitled to know those two things. But aside from that, no objection to your response.
All right, very well. So I'll give us the bailiff to take back in there and come on over, get working on that with defense counsel. I assume we'll get an answer back from the jury pretty quickly. And once I get that answer, I'll come back into court and let you know what they say.
Sounds good. Thank you, Judge.
All right, we'll stand in recess. Thanks.
All right, I'm going to queue up the next one real quick. This is going a bit longer. It's 30 minutes. And I see them stand up once or twice. So I don't know if I just got cut off. This one is a little bit longer. It's like 30 minutes. And I see them stand up once or twice. So I think they bring the jury in. Yeah, here we go.
Nope, we don't have anybody here. Thanks, everyone. Have a seat. I think the prosecutors are on their way. You can go ahead. Go back there. Just hold, no, don't open it. Just hold on to it. Everybody ready? All right, we're back on the record in State versus Kelly. The records show the presence of all counsel and the defendant. About 10 minutes ago, we got another note from the jurors. For the record, I previously instructed my judicial assistant, Jose, who's also the bailiff, that if the jury ever submitted a note that had any kind of tally or numerical representation about what their votes were, he was to close the note and not show me the note. And the reason I did that is I've had this happen in a number of trials before. The jury instructions, the final jury instructions that I gave clearly state to the jurors, and I think I emphasized to them again, if you have a vote and you have a note, you're not to inform the court about where you are in the vote numerically. Well, apparently they've done that. Now, I haven't seen it. I intentionally didn't look at it. I had them staple it and gave it to the clerk. If you would just write on there, Valeria, one that came in about 1:45 today on April 19th, but I haven't seen it. So I don't know what it says, and I don't think it's appropriate under the law for me to look at it. And that's all apparently it's in the note. It just has, my understanding, it has the counts of the charge and just some kind of tally of where they are. And then they told the bailiff orally, well, what do we do now? And I sent the bailiff back to give them instructions. Any questions for the court have to be put in writing. So that's where we are. But in the note doesn't ask the court to do anything at this particular point in time.
Your Honor, I still don't think we've answered their questions from earlier.
I did answer their questions, but they haven't sent the answer back. So a question on the limiting instruction, I read it, and it says we can do this either way or both ways. We can answer your question. We can provide you with that information. And tell us what you want us to do. And we haven't heard them back. So if they had answered back, then we would have gone forward. But right now, putting that aside, let me hear from the parties. I mean, I haven't been asked to do anything. And so unless and until I'm ever asked by them to do anything, my intention is not to respond.
Well, it's the state's position that we need to give a full response to their request on the limiting instructions. So the state is still requesting that, specifically with request to Detective Rodriguez.
All right, I know what your request is. I'm not going to do it. I already responded to that request. I responded to the request that they gave me. I told them what we can do. I said the court can respond. We can give you all this information. If you have some specific area of concern that you want, we'll answer that. If you want it all answered, if you want us to tell you about all the limiting instructions we gave, we'll give you that detail as well. Put it back in that court. Haven't heard back from them. From that, I assume it's not that important at this point in time. Anything else record you want to make about the note that was just sent out, other than what you've already stated?
It sounds like you've already responded, Judge? Or-
No, there's nothing to respond to. They just sent a note out with a tally about where they were on the various counts. And I haven't responded in any way, except the bailiff told me they orally told him, well, what do we do now?
Well, if you let me see that note real quick, I will let you know what to do, Judge.
And he did not respond appropriately, and he informed me of that. And I sent the bailiff back and said, if you have any questions of the court whatsoever, everything has to be done in writing. And that's where it sits. What's the defense position?
I think we can leave it there unless and until they send us something that is in writing. If they say we're stuck or something like that, then we can give an impasse instruction. But I think we need to wait for something from them.
That's what I think as well. But start looking at that. I think generically they're called Willits instructions. There's a Arizona revised.
It's not called Willits, Your Honor.
I mean, that's what we
Willits.
kind of colloquially had referred to them. But there is an Arizona revised jury instruction that is recommended for the court to give, if appropriate, under the circumstances, when the jury has indicated they're at an impasse.
I was just wondering, Judge, if you wanted to send a note to remind them to not tally up on future notes. And I don't know, whether it's necessary or not, I'm not sure. I mean, we hate to come back with.
It can't hurt. I mean,
Because you don't want another one saying we're hung, we can't figure out what do we do, here's our tally, and then it makes it where you can't read it.
can't even read the note. Right,
Yeah.
That's true. All right, I think that's a good idea. Let me have some kind of
Something to write with you?
something.
You're right. And I know you believe that I've made my record, but I indicated earlier I needed to make a further record, and I would like to make that further record, which
You
is
can
that
do
the
that,
state-
but I'm trying to deal with an immediate
Sure.
issue right now. So let me deal with this.
You just pop into Westlaw.
All right, so, and I'll put April 19th, 2:05 PM. Jurors, you are reminded not to inform the court, bailiff, or anyone else what your numerical vote counts are on the charges. All right, I'll give this to, any objection from the state?
No objection, Judge. And just
All
for
right,
the
let me give
record,
this, we'll have the bailiff take that.
and just for the record, Your Honor, I think you meant an Allen instruction. Willits is if there's lost or destroyed evidence.
Oh, that's right. You're
Is that
right.
what you
Yeah.
meant?
Yeah, I'm sorry, I forgot that. Thank you for correcting me. Do you have that? Does everybody have that proposed, Raji? We're not there yet. I just take a look at it.
Standard 53, is that what we're talking about? The impasse instruction?
You're right. I think so.
I
Are-
have it in front of me.
Okay, take a look at that. We're not there yet, but the way things look, we may be soon. For the record, the jury began deliberations at 8:30 this morning. Well, let's go back. Yesterday, they began deliberations at 2:40. It took us a little while to get some of the exhibits back in there. They recessed at 4:30, so that was an hour and 15 minutes. They began deliberations at 8:30 this morning. We got the note at about 1:45, 1:50. They did have lunch brought in. I don't know if they worked through lunch or not, but they began at 8:30 this morning and sent the note out at about 1:45, 1:50, and stayed in for lunch. Ms. Hundley, you can make an offer of proof and a record. Why don't you just print something up? I've got other things I need to do. If you would write something and print something up, and then you can file it and make it part of the record.
Well, Your Honor, it's just the document I already prepared and already submitted to the court that I just believe the state is prejudiced without the jury receiving that information.
Mm-hmm.
And I don't believe they know how to ask for it because they don't know what it is that they need the information on. So I think pitching it back to them is not appropriate. I think that we should offer them the information that they asked for.
Okay,
That's all.
understood. Any change in the position from the defense on that?
No.
All right, stand by. We'll be in recess.
Please rise.
Okay. That was pretty good. I think this is real short. Yeah, it is real short.
Not unexpectedly, the record will show the presence of counsel, the defendant and defense counsel. Not unexpectedly, we just got another note. I marked it 2:10 p.m. The note reads as follows. We, as a jury, are at an impasse as to a unanimous verdict. We're looking for guidance as to how best to proceed. I'll give a note to the clerk. What's the defense position?
I don't know that we need to give the impasse instruction just yet. I think maybe just another note
I
saying.
can't hear it. I don't think.
Oh, I don't think we need to give the impasse instruction just yet. Maybe another note saying, do your best, see if you can make any progress.
I think when the jury indicates they're at an impasse, we have to give the impasse instruction.
So the impasse instruction, just make sure we all have the same thing. We're looking at the same thing as Standard Criminal 53, and it reads as follows. This is offered to help you, not to force you to reach a verdict. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a just verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your views and change your opinion if you become convinced that it is wrong. However, you should not change your belief concerning the weight or effect of the evidence solely because of the opinions of your fellow jurors or for the mere purpose of returning a verdict. You may wish to identify areas of agreement and disagreement and then discuss the law and the evidence as they relate to the areas of disagreement. If you still disagree, you may wish to tell the attorneys and me which issues, questions, law, or facts you would like us to assist you with. If you decide to follow these steps, please write down the issues where further assistance might help you bring about a verdict and give the note to the bailiff. The attorneys and I will then discuss your note and try to help you. I do not wish or intend to force a verdict. We are merely trying to be responsive to your apparent need for help. If it is possible that you could reach a verdict as a result of this procedure, you should consider doing so. Please take a few minutes and discuss this instruction among yourselves. Then advise me in writing of whether we can attempt to assist you in the manner indicated above, or whether you do not believe that such assistance and additional deliberation would assist you in reaching a verdict. If we're going to give them an instruction, I think we ought to give them this one because it's crafted to be neutral, offering help, clearly states we're not intending to try to force a verdict, coerce a verdict, or influence a verdict. It's just tell us whether you need help. Can we help you? Is additional time needed, or are you clearly at an impasse?
In my experience with my background, I have found that sending them back to do their due diligence, some note to say, keep trying before they just throw the towel in easily, and then follow up with this has helped a lot where we did get verdicts. It's just my experience.
The state opposes that, Your Honor. We'd ask for the impasse instruction. It's specifically designed for this situation and, as the court indicated, is neutral.
Let me get a formal statement from the defense. You, co-counsel, you can talk together, talk to your client if you need to. It's an important decision. If you want to involve him, do so. I can step off even, but really the question is whether or not I give this impasse instruction. If I give further instruction, I think it's appropriate to give the impasse instruction because it's crafted to comply with the case law and to be neutral and to be non-coercive.
The instruction is not a concern. We know that's crafted for that purpose, and so that's not our objection. We would just like them to continue trying for a while before they get back and give us more information that they absolutely can't. The same issues may be the same issues in another trial down the road. So I think what I have found by just asking them to get back to work and continue to try, and then maybe they'll diligently try a little harder and then follow up with this impasse note if we get another one down the road.
All right, I understand your position, but if I am going to give a reply, a response, then I'm going to give this instruction. But I won't give it. Well, I'll consider not giving it if the defense objects. I mean, you want to talk?
We'll take a minute.
Okay, I'll come back in a couple minutes. We'll be in recess for 5-10 minutes.
Please rise, keep it order.
With as many trials as we do every day here, we should have this part pretty much figured out what to do right now.
Why don't you go see if the defense people. Go get the defense. Thank you.
Someone go find the defense. We got to get this thing going. Where'd defense go? Ah, you tricked me. I thought you were defense. Oh, here comes one. Two.
We're back on the record. Records for the presence of counsel and the defendant. I've been thinking some more, and I am going to. I'm going to do what defense counsel suggested. This jury, as I said, went out at 2:40 yesterday. It took us a while to get the evidence in there, and they did deliberate a little bit yesterday, and they deliberated today from 8:30 to a little bit before 2 with a lunch break. Not sure whether they worked before lunch. It's a 4-week trial, a lot of complex information, a lot of proof, a lot of evidence presented, and there's a lot of issues. I mean, there's no question. There's a lot of facts to be looked at in this case. I just don't think
Yo, the judge is never going to rule in her favor for anything. He just keeps shooting her down and letting the defense have what they want.
they've worked long enough or hard enough at it. So I'm going to bring them in and I'm going to tell them, number one, I don't know what their vote count is. And again, they're not to tell me, but it's a 4-week trial. A lot of work and effort's been put into it. I'm not trying to coerce a verdict or influence them in any way, but I think they just need to keep working. Another possibility would be, we are here on a Friday afternoon. I'm always concerned when a case goes to a jury on a Friday and a Friday afternoon that influences their process. Another option I can offer them is, look, if you want to break today and come back Monday and start again Monday, that's another thing we can offer you. Sometimes that's an effective thing to do, which is just to take a break and come back and start afresh on another day.
For the record, the state opposes that, Your Honor. We're asking for the impasse instruction. I believe it's specifically designed for the situation. The jury specifically said they're at an impasse, and that covers all of the issues.
We're in agreement with your suggestion, Your Honor.
Okay, then let's bring in the jurors. Please rise. All right, yeah, sit anywhere you want, ladies and gentlemen. Please have a seat, everyone. All right, the records show the presence of all of the 8 active deliberating jurors, counsel, and the defendant. Good afternoon, ladies and gentlemen. I've been reading your notes, discussing your notes, and content your notes with the lawyers. It's 2:35 today on a Friday. This case went to you for your deliberations, ladies and gentlemen, about 2:40 yesterday afternoon on Thursday. We took a while to get the evidence together, put it all together so you could have it all available to you in the jury room. Then my understanding is you began your deliberations again this morning at 8:30. You had lunch. I don't know, did you work through lunch or did you just take a lunch break? Work through lunch. All right, that's good to know as well. And then your latest note came in at 1:50 p.m. about the situation. Again, just to remind you, I know I've written it back in the note, do not advise me numerically of where you are voting, okay? I had it stapled up and filed with the clerk, so I don't know where you are. Please don't do that again. That has an effect that I wish to avoid. Now, I have to tell you, it's my opinion that you haven't worked at this long enough. This was a 4-week trial. A lot of evidence was presented, a lot of information, some of it very complex from a variety of different witnesses. I mean, I don't know how many witnesses we had testify, but quite a few, and they all gave important information. Some very complex information. I understand the issues are complex, but to come back on a Friday at about 1:50, I don't think you've worked at this long enough. I am not trying to force or coerce a verdict, all right? That is not my intention, and that's not my job, and that is not what I'm doing. But I do have a responsibility after a tremendous amount of work has been put in to getting this trial to this place where we are, by the lawyers, by the court, all the resources that have gone into it, and all the evidence that's been presented to make sure that you do your job, follow your oaths, and to work as hard and long as you possibly can to reach a verdict. Again, I'm not trying to force or coerce a verdict. And if there's things that you need and we can help you with, other information or evidence, that's what we're here to do. But in my opinion, which is the one that matters at this point, you have not worked at this long enough. So I'm going to send you back in a moment to continue the deliberations. Now, also, it's a Friday afternoon, and from my experience, from a lot of trials I've done, sometimes, this is something else for you to consider, sometimes it's good to take a break. I know everyone's prepared and eager to resolve this matter in this case, but another option would you can be recessed for the day and come back Monday. Sometimes it's good to take a break, step away from it and come back as a group, again, 8 persons on Monday after a weekend and start the deliberations again. So that's another option for you. So what we're going to do is I'm going to send you back in the jury room. I want you to keep deliberating, discuss it, keep an open mind, reevaluate your positions if you feel that's appropriate, and continue to work on this case. All right? And if you decide you want to break for today and come back on Monday, as I've suggested, pass a note to the bailiff, and then we'll just excuse you for the day and tell you to come back Monday at 8:30. But I want you to keep working. All right? You're excused to continue deliberations. Thank you.
Please rise if you prefer.
Well, Judge,
The record will show the absence of the jurors. I kind of doubt they'll take me up on it, but if they do take me up on it and decide they want to come back Monday, we'll let you know right away. All right? Otherwise, stand by, and we're in recess. Thanks.
Please rise.
All right, we got another note from the jurors. I had it shown to counsel just because this juror writes so small. I just want to make sure you have the same reading of it that I do. The way I read this, were the SO reports entered into evidence? If so, can they be shared with the jury? Is that the way you folks read it? All right. Let me hear from the state first.
Your Honor, I think we have to answer, they have all the evidence that's been admitted.
That's fair enough, Your Honor.
All right.
I think we can tell them that they can have additional testimony if they request it as well. There's an additional instruction that indicates that and a rule that allows it as well,
And
if
our
that would help
position,
them.
our position would be to not suggest that.
We didn't have any reports that were admitted, right, from the sheriff's department?
That's correct.
Not police reports, Your Honor.
Right.
Obviously, that's because we can't admit them because they're hearsay.
All right, so my response is, by rule, the admission of evidence stops at the close of the trial. No other evidence can be admitted. The SO reports were not admitted during trial, hence they are not in evidence and therefore cannot be shared with the jury. Any objection?
Yes, the state objects, Your Honor. It sounds like we could admit them, which we cannot. They're hearsay. And I think that improperly emphasizes that they weren't admitted and seems to point the blame at the state for not admitting evidence, which we're not allowed to admit.
I don't have a
Yeah, the
position,
point
Judge. I,
there.
I think how you crafted it is fine, but I understand the state's objection.
This is the instruction, or the answer I'm going to give to the jury. And it's 3:15. We're in recess.
Please
No,
rise and give
lady,
the floor.
you're getting nothing from this judge. I don't know what you did, but maybe you should let him talk for a little bit.
All right, we're back on the record. In State versus Kelly, the records show the presence of all counsel and the defendant. It's 4 p.m. I marked this latest note from the jurors, 4 p.m. The note says, jurors would like to be dismissed and to return Monday at 8:30 a.m. Any objection?
No.
No.
No, Your Honor.
All right, so I'm going to write, you are dismissed. Response I wrote is as follows. You are dismissed. Please return to the jury deliberation room Monday at 8:30 a.m. to continue your deliberations. Remember and comply with the admonition of the court.
That works for us, Your Honor.
Yes, Your Honor.
All right, I'll sign it, Judge Fink. Hand it to the bailiff to be delivered to the clerk. And we're adjourned until 8:30 a.m. Monday morning. Have a good weekend.
Your Honor, could I address one issue first? We've requested a copy of the JAVS recordings of the trial in this case, and pursuant to Administrative Order Number 2007-015, it indicates that if a party requests a copy of the JAVS recordings, they're entitled to them. And I was told by the clerk of court that the court was indicating I'm not entitled to them, so I'm just trying to sort that out.
I understand. It's been brought to my attention. Put your request in writing, file it with the clerk in connection with this case, and the court will give you a ruling.
Okay.
We're adjourned until 8:30.
Please rise and give the floor.
Well, what did she do for real, though? Okay, one more video. Here we go. It's the verdict next. We finally made it. No, 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 no. Obviously, at this point, it's very important for me to stop real quick before we get the verdict. And thank you so much for joining me through all of these long videos with repeating over and over again to watch the Kelly trial with me. I actually learned a lot doing this so I can move on to a bigger, better project. So you were my guinea pigs, and I love you so much for making it through to the end with me. But we finally made it to the end. Here comes the verdict. I'm going to stop talking.
Thank you. Please be seated. All right. The records show the presence of Ms. Hunley for the state, counsel for the defendant, and the defendant. The jury is absent. The jury began deliberations this morning again at 8:30 in the morning. They took a break for lunch at 2:50 p.m. The jury forwarded the following note to the bailiff, who forwarded it to me, and copies have been provided to all counsel. Judge Fink, the jury is still at an impasse, and we don't feel further deliberations will
I think that's net, Your Honor.
net. We do not feel that further deliberations will net a unanimous decision. Are there additional instructions we can follow? Signed, juror number 1, who's the foreperson. I mark the time, and I'll give the note to the clerk with today's date, 4/22/24. All right. Let me hear from the state, and then I'll hear from the defense. Ms. Hunley.
Your Honor, the state requests that we provide the impasse instruction provided in the Raji's.
The standard criminal 53.
Yes, Your Honor.
Thank you.
We're in agreement with that, Your Honor. We think it's time for that instruction.
All right, and before we get there, I waited a few minutes before I came in to make sure you had time to discuss the situation with your client. But if you need more time, I'm happy to give it to you. I want to make sure you've had a time to consult with Mr. Kelly.
I think we're okay, Your Honor.
All right, so everyone is in agreement the court should give standard criminal 53 impasse instruction, right?
Yes, Your Honor.
Yes.
All right, very well. Then let's bring in the jurors.
Oh, she was the first one to stand for the first time the whole trial.
Please rise.
Thank you. Please be seated. The record will show the presence of all 8 jurors, counsel, and the defendant. Good afternoon, ladies and gentlemen. I received a note from juror number 1, who is the spokesperson, I assume the foreperson for the jury, that the jury is at an impasse. And the request was, are there any other instructions that we can follow? I do have an instruction. It's a formal instruction. I'm going to read it to you now, so please pay close attention. This is offered to help you, not to force you reach a verdict. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a just verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and change your opinion if you become convinced that it is wrong. However, you should not change your belief concerning the weight or effect of the evidence solely because of the opinions of your fellow jurors or for the mere purpose of returning a verdict. You may wish to identify areas of agreement and disagreement and then discuss the law and the evidence as they relate to the areas of disagreement. If you still disagree, you may wish to tell the attorneys and me which issues, questions, law, or facts you would like us to assist you with. If you decide to follow these steps, please write down the issues where further assistance might help bring about a verdict and give the note to the bailiff. The attorneys and I will then discuss your note and will try to help you. I do not wish or intend to force a verdict. We are merely trying to be responsive to your apparent need for help. If it is possible that you could reach a verdict as a result of this procedure, you should consider doing so. Please take a few minutes and discuss this instruction among yourselves. Then advise me in writing of whether we can attempt to assist you in the manner indicated above, or whether you do not believe that such assistance and additional deliberation would assist you in reaching a verdict. That's my additional instruction to you. If any of you wish me to read it again, it's very important. If you need to hear it again, I'm happy to do it. All right, seeing none. Did you understand the instruction? Very well. I'm excusing you once more to deliberate further and consider this additional instruction that I've given you. We'll stand in recess until we hear from the jurors.
Please rise and give the vote.
They never leave the box. What do you think? Oh, no. We still got more. I can't fast forward it. Miss Henley's going to get shut down a little bit more. What do you think? No breaks. No breaks. It's a whole video. Oh. The judge left. Oh, wait, I just checked that. Did I not just check that? Okay.
Thank you. Please be seated. Records show the jury is absent, counsel are present, and the defendant is present. The jury sent out another note at 4 p.m. and copies were made and distributed to counsel. Dear Judge Fink, the jury followed your latest instructions and don't believe we can render a unanimous decision on either count. That's signed by the jury foreperson, juror number 1. Then it says we also need clarification on verdict forms. We also need clarification on the verdict forms based on the above. All right. What's the state's position first as to the first issue? Well, as to both, I guess, really, because they're interconnected.
Your Honor, I think we just tell them that if they're at an impasse and can't reach a verdict, then they don't have to do anything with the verdict forms.
I think that answers question number 2. I'd ask that we just reiterate the impasse instruction and ask them to continue deliberating and see if they can make progress.
What about the verdict form? I mean, I'm not sure what that, I'm not sure what that means. I mean, it would seem to me,
I think they're
it would seem to me that if you're at an impasse, you're at an impasse as to everything. And I'm not really sure what the issue would be on the verdict form. That concerns me a little bit because the possibility of what they're doing on the verdict form might be inconsistent with what they're saying otherwise, but that's some speculation on my part. Yeah.
I think it's because there's not a final checkbox that says we cannot agree on the less final of the lesser includeds. I think that's why they're confused. Because they've probably gone through and decided we can't agree on this, we can't agree on this, and now they're at the third one and there's nowhere to check the box. We can't agree. Do we have to fill it
Oh,
in?
right, because the last lesser included just says guilty or not guilty.
And so does the second count. It doesn't have a we cannot agree. So I think that may be the confusion. Like, do we still have to fill this form out? What do we do with the forms?
Okay.
But, and as to counsel's first point, I think at this point it would be coercive for us to indicate that they should continue to deliberate, but that would be the state's position, Your Honor, and I would defer to the court on that.
All right, thank you. And defense, what's your reasoning?
Just that you only gave them that instruction, I think, 30 minutes or something before they came back out with what they stated. It's been a long trial. I think they're at the end of a really long day. They looked pretty exhausted when you brought them out here. So I think it would be beneficial to at least give them an opportunity perhaps to break for the day and try again tomorrow. And if they can't, they can't. But You recently gave them that instruction.
And my concerns, Judge, is the 30-day trial, the cost, the time, the expense that not only this county, but each of the parties, it's not an easy one to give up too soon, because then we have to potentially try it again, depending on the state, and that expense will be put out there again.
No, I understand, agree, believe me. Well, what Ms. Larkin is suggesting is that I offer them, once again, the opportunity to avail themselves of another break and come back tomorrow. And I'm willing to do that. I don't. So would you like me to craft a response that basically says that the court can offer you an opportunity once again to, if it would be useful to you, to take another break, come back tomorrow morning and reinitiate jury deliberations?
That works for us, Your Honor.
And then allow them to respond, Judge? Is that the intent, to
Right.
elicit a response from them?
Right.
I don't have any objection to that, Judge, if they think it would be helpful.
I mean, I think you have to offer them something different other than just keep deliberating. That obviously hasn't been productive to keep deliberating right now. But I did notice when they came in, there was obviously, it's difficult to judge, or to draw conclusions from what you see, but there was obviously some frustration there that I hadn't seen before, which is understandable, but a break might help. So, all right, give me a minute.
And then as to the second one, were we going to respond on that? Just tell them if they're at an impasse, they don't have to fill out the verdict forms, or how do we address that?
What's the defense position on that?
Judge, that's fine with us if we could just instruct them that if they can't come to an agreement, they don't have to mark anything on a verdict form.
If you cannot come to an unanimous agreement on any of the charges, then you do not have to fill out the verdict form.
Right.
Okay. Give me a second.
Will she give him a second, or will she bring up something else? Your Honor, I just want to reiterate all of the objections I had throughout the whole trial for the record in case of appeal. Oh, no, not appeal. In case they retry.
Although, Your Honor, I suppose it's possible that they didn't quite understand the lesser includeds. I don't know if the court wants to just explain to them again. I hate to give up an opportunity for them to resolve the case if they have the ability to do so. I'll just throw that out there for the court.
And Your Honor, defense would object to that. I'm fairly confident by now everybody watching these Kelly videos with me has already looked up the ending.
Could you run me a copy of that verdict form?
Please hurry, Judge. I'm late for Judge Reese's trial.
Judge.
Deliberations again tomorrow morning, if you believe that would be helpful. All right, so here's what I wrote. The court understands that you have continued to work hard to come to verdicts. The court can offer you the opportunity to once again recess for the evening and to resume deliberations again tomorrow morning, if you believe that would be helpful. As to the verdict forms, I am not sure what your issue is without more specificity. If, however, you are unable to reach unanimous verdicts on any count, then you need not fill out the verdict form. Thank you. You will instead report to the court that you simply are not able to reach verdicts. Any objection from the state?
No, Judge.
No objection.
All right, it's 4:18 p.m. I'll give the note to the bailiff with my response. And if there's nothing else, we're in recess.
Please rise and be before.
Okay, this is going to be quick because I didn't see it. Oh, I think they cut out the recesses.
Thank you. Please be seated. Jury's absent. Yeah, go ahead. All right, the records show the presence of the defendant, counsel for both sides. The jury sent back another note. This note came in just a couple minutes ago. It was response to my note, and it says as follows. Thank you, Judge Fink. We do not believe resuming deliberations will change juror opinions. It's signed juror number 1. What's the request of the state?
Your Honor, the state requests that the court declare a mistrial.
And for the record, Judge, we object, and we would ask that they be brought back tomorrow to continue deliberations.
All right. I'm going to, I understand your position, protecting the record, but I think the jury has made it abundantly clear, beginning yesterday, which was too early, but then they continued to deliberate. They deliberated another hour and a half or 2 hours yesterday afternoon, and not yesterday afternoon, but Friday afternoon, and then deliberated all day today, and they just seem deadlocked. So I'm going to declare a mistrial. Let's bring in the jurors.
Your Honor, the state would request an opportunity to speak to anyone on the jury who's willing to speak to the state.
It's over.
As you know, I customarily meet with them first, thank them for their service, and then I'll inform them of your requests.
Thank you. And the victims are on the way over, Your Honor.
And I think we'll do is set the matter for status in a couple weeks.
I think we only have 60 days to reset it, Your Honor, so I'd ask that we set it for next Monday. I think we'll have a decision by then.
Okay. Any issue with that from the defense? Setting a status next Monday, so see what the state's position is.
Sure. Would that be afternoon calendar, right?
Yes,
That's fine with me, Judge.
Can
Okay.
I,
you can appear remotely.
thank you. I don't.
Please rise.
All right, thank you, everyone. Please be seated. The record will show the presence of the jurors, counsel, and the defendant. I've read your note. Juror number 1, I believe you're the designated foreperson. Is that correct? All right, sir. Is it your opinion as the foreperson that if the court were to provide you with additional time and any other resources or any other materials or evidence that I can, that would not be a fruitful endeavor, and you would still, as a juror, be deadlocked and unable to reach a verdict?
We would still be deadlocked and not be able to reach a verdict, Your Honor.
And is the jury deadlocked and not able to render a unanimous decision on any of the counts?
Yes.
Very well. Any other record that counsel wishes the court to make at this point in time?
No, Your Honor, thank you.
No, Your Honor.
Very well. Ladies and gentlemen of the jury, I'm going to excuse you. If you'd go back to the jury room, well, you are excused. You are relieved of the admonition of the court. And I'll discuss that with you some more when I come back to the jury room. But it's my practice to always meet with the jurors after the deliberations and after a trial and thank them for their service and answer any questions that you have that I might be able to answer. So if you wouldn't mind, this will just be a moment going back to the jury room. And I know it's 4:35 or so, but I'll be back there very shortly to thank you for your service. You are excused. You're released from the admonition, and you are excused to go back and retire to the jury room.
Please rise, por favor.
Mistrial. Mistrial. Nobody in the gallery is freaking out, so that's good.
All right, please have a seat. The record will show the absence of the jurors based upon the jury's inability to reach a verdict on any account. The court orders that a mistrial, that this case is in mistrial. The court will set a status hearing for next Monday on the court's usual law and motion calendar for 1:30 to allow the state to take a look at the situation and decide whether or not it wishes to ask the court to reset the matter for trial. I also want to remind the parties, notwithstanding that any post-trial motions are due under Rule 20 or any other rule that's applicable within 10 days from today's date. So be aware of those time limits.
Your Honor, the state does have 2 pending motions. It would be very helpful if the court ruled on those because we do need that material to make a decision about what we're going to do next. We've asked for the JAFS recordings of the trial and also copies of the questions by the jury post-closing argument and the court's responses thereto. So we're attempting to make some decisions.
Understood. All right, very well. I'll inform the jurors of your desire to speak with them. I'm going to go back and thank them for their service. Is there anything else from counsel?
Just that we'd like to speak to them, Your Honor.
Right.
We would too, Judge.
Very well. I'll communicate that to them. I'll give this final note to the clerk, and we are adjourned. Thank you.
Yo, Judge, ignoring her is not helpful because she's just going to keep bringing it up again and again and again. Guys, we made it. We made it. I'm so happy we made it. Mistrial. George Kelly gets to go home with his gun. Yes, he does. Wanda's happy. She's going to make him one of those pineapple sandwiches. Thank you so much for coming out. Thank you so much for watching this, guys. I hope you have a great day, and I'll see you at the next one.
Got these life that goes digital dreams through the screen. Her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh